So we're delighted to welcome Dr. Hedi Viterbo as our first speaker for this term. Hedi is a senior lecturer at Queen Mary University of London and has been a visiting scholar at Harvard Law School and a visiting researcher at Columbia University. His work spans a critical legal studies approach to state violence, sexuality, and the construction of childhood, focusing on Israel and Palestine, but also encompassing global perspectives. He has recently published his second book, Problematizing Law, Rights, and Childhood in Israel-Palestine, and there are some more details about this book in the chat, which you'll see. Excitingly, he'll be launching soon the Childhood Law and Policy Network, consisting of a website and social media network. And this brings us together as scholars and practitioners from around the world working on social, political, legal, and policy issues concerning children and childhood. And I hope he'll be able to tell us a little bit more about this. I'll pass over now. Thank you so much for joining us.
Thank you very much, Chelsea, and many thanks to you and to Charlotte and to the Children's Rights Network for the invitation. And also thanks to the Bonavero Institute for hosting us today. I will say a couple of words about this new network that you mentioned. Essentially, I'm inviting everyone attending today to get in touch if you'd like to join as a member. It doesn't require anything in particular being a member, other than being part of this network, which is really aimed to showcase work in the field of policies and laws and socio-political issues relating to children and childhood, and also to facilitate networking. So just feel free to get in touch, everyone. I'll try to share my slides. Are you able to see them? Fantastic. Okay, so as Chelsea mentioned, today's talk is based on my new book, which is similarly titled Problematizing Law, Rights, and Childhood in Israel-Palestine. And the book is a culmination of 14 years of research. It offers an interdisciplinary rethinking of the relationship between human rights, law, childhood, and state violence. And the book is highly critical of Israel in various ways, but at the same time, it also challenges some common criticisms of Israel. And I argue that these criticisms are conceptually limited, that they're factually inaccurate, and no less importantly, that they're politically problematic. And since similar criticisms are widespread around the world, many of the arguments in the book are applicable much more broadly beyond the context of Israel-Palestine. So I'd like to start by briefly outlining some of these common criticisms of Israel. And for each criticism, I'll explain how the book challenges and complicates it. And I'll also illustrate this with some examples. So as you can see, the first criticism is that Israel simply disregards human rights and international law. This actually couldn't be further from the truth. So the book reveals how Israel has pursued a much more sophisticated course of action. It's been increasingly using international law and children's rights to perfect and legitimize its violence against Palestinians. So throughout the book, both law and rights are shown to help Israel in its efforts to subjugate Palestinian lives, minds, bodies, and interactions. Israel uses law and rights to govern and discipline all the Palestinians through their young. It uses the language of international law and child rights to justify military offensives, the use of human shields and torture, the mass incarceration of Palestinians, and many other forms of state violence. And it presents much of this as serving the best interests of the child. So let's have a look at an example, which is discussed in the book. And it has to do with two things. One is a high-profile report by a delegation of British lawyers. The other is a series of reforms that Israel made to the laws that it applies to Palestinian children. And many of these reforms concern the military laws that Israel applied to non-citizen Palestinians in the West Bank. And I'm happy to provide some further geopolitical context if anyone's interested later. As the book explains, quite a few of these military laws are actually based on British colonial laws. So every year, Israel prosecutes thousands of Palestinians in military courts, including hundreds of children. For the sake of comparison, the rate of non-citizen Palestinian children in Israeli custody is 3 times higher than the child detention per capita rate here in the UK. And these figures don't even include the thousands of additional Palestinian children who are tried in Palestinian courts. 10 years ago, a delegation of British lawyers published a report on the treatment of Palestinian children in Israeli military custody. The delegation was funded and facilitated by the British Foreign Office, and 2 of its members were a former Attorney General and a former High Court judge. The report attracted media attention both in the UK, as you can see, and in Israel. As part of its work on this report, the delegation visited Israel and met with senior officials and state lawyers there. 10 days after the delegation returned to the UK to compile its report, the Israeli military swiftly raised the age of criminal majority for Palestinians. Previously, the Israeli military law had defined Palestinians aged 16 and over as adults. Now, the age of majority was raised to 18 years, in line with international legal standards. The military made sure to widely publicize this reform, both in English and in Hebrew. The same year, the Israeli Military Advocate General wrote the following in its annual report, and I quote, "There has been increased engagement by human rights organizations and other international bodies in the ways the Israeli law enforcement authorities treat Palestinian juvenile offenders. As a result, activity has taken place at headquarter level to amend the relevant security legislation, with military prosecution officers even escorting a number of delegations to Israel and responding in writing to several international reports on this matter." In fact, over the last 2 decades, Israel has made a long series of legal reforms concerning Palestinian children. The reform I've just mentioned was only a small part of this broader trend. And these reforms were made following sustained pressure from the human rights community. Israel made sure to publicize them as broadly as possible. For example, since 2013, the military has been handing out to foreign delegations a leaflet in English. Here's a quote from the leaflet, which highlights some of the reforms I'm talking about. And I quote, "Within the military's efforts to protect the rights of all Palestinian defendants, and particularly minors, a juvenile military court was established, which guarantees adequate and professional care for juveniles and recognizes their welfare and best interests as a factor in the proceedings. The amended military law provides for a separation between detained minors and adults, as well as a wide range of additional provisions. In 2011, an amendment to the military law raised the age of majority from 16 to 18 years, end quote. Some audiences seem to have been convinced by the Israeli military's claims. Among them is a spokesperson for the British Foreign Office. 4 years ago, when asked about the matter, the spokesperson cited, and I quote, "some improvements/progress by Israel, including the establishment of separate military juvenile courts." Contrary to these statements, the book reveals how none of the Israeli reforms benefited Palestinians. Some of them were simply token reforms, which made no actual difference to how Palestinian children are treated in practice, although they look very good and they serve as a potential PR tool. Other reforms actually harmed Palestinian children and also Palestinian adults, and I'll return to this issue shortly. So as you can see, Israel doesn't simply contest or deny allegations that it violates international children's rights norms. Instead, what Israel does is develop new legal means to fend off the criticism. Rather than flouting child rights law, Israeli authorities find new and creative ways to deploy it to their benefit. So far, I've discussed the myth that Israel simply disregards human rights and international law. A second criticism that is often made is that children need special protection. And that Israel denies them this special protection. So take, for example, the report of the British Delegation of Lawyers. Here's a quote from the report. Under the UN Convention on the Rights of the Child needs special safeguards. International law, international humanitarian law, and the Convention on the Rights of the Child should be fully and effectively implemented by Israel. The international legal principle of the best interest of the child should be the primary consideration in all actions concerning children. In the book, I challenge this rhetoric from three angles. First, it assumes that childhood is a natural and universal category. According to this view, childhood is a distinct stage of development and socialization, and this childhood is then contrasted with adulthood. So the archetypal child is perceived as relatively dependent, vulnerable, incomplete, developing, ignorant, and impulsive, which is seen as requiring special protection and supervision. In contrast, the archetypal adult is considered relatively autonomous, responsible, informed, competent, and fully formed. In this way, the special protection rhetoric and children's rights more broadly are essentialist. And by this, I mean that they portray both the child and the adult as distinct categories with an essential and intrinsic nature. The book draws on an extensive body of scholarship that challenges this dominant view. As I argue in the book, law and human rights don't simply regulate or respond to pre-existing children and adults. Instead, they're deeply implicated in the social production of both childhood and adulthood. They manufacture childhood and adulthood as categories. They reinforce these categories. They negotiate or challenge them, and they weaponize them in multiple ways. As I mentioned earlier, another finding of the book is that the rhetoric of special protection and of children's rights generally is harmful to the young people that it claims to serve. The book reveals how this rhetoric exposes Palestinian children to greater harm, how it disempowers them, and also how it misrepresents their own voices. The human rights community is heavily implicated in all of these issues, and I'll provide a few specific examples shortly. But the special protection discourse harms Palestinians of all ages. The book exposes how children's rights are about adults, no less than children. And specifically, I examine how children's rights end up creating and legitimizing various forms of Israeli state violence against Palestinian adults. I show how children's rights pave the way for apathy and even punitiveness towards adults, especially if they're men, and even more so if they're Muslim men. And I expose how the human rights community also contributes to these problems. So let's have a look at a few examples. The first one has to do with what I call generational segregation. Under international law, children must be separated from adults in prison. In the past, Israel imprisoned most Palestinian children and adults in the same facilities. This led to extensive criticism from the human rights community, and eventually Israel separated Palestinian children, both in detention facilities and in prisons. As I mentioned earlier, this is part of a series of reforms that Israel has made, which were either tokenistic or even harmful to Palestinians. So let's see why this reform works to the detriment of Palestinians. First of all, the Palestinian adults that I'm talking about are not criminals in the common sense of the word. Instead, they often describe themselves as political prisoners or freedom fighters. In addition, the book draws on Palestinian sources to show how, before they were separated, these adults offered the children valuable support and care. They provided the children with emotional support, material care, and educational services, none of which Israel provides. And these Palestinian adults also represented the children's concerns to the Israeli staff. Considering that Palestinian children in Israeli custody rarely get to meet their family, these adults were the closest substitute to parents. So now, in the name of children's rights, Palestinian children have been denied a crucial source of support. In addition, the separation of Palestinian children in Israeli custody has exposed them to greater harm. Now that they no longer have Palestinian adults nearby, they're more vulnerable to abuse by the Israeli security agents. And we know that Palestinian children, once they're released from Israeli prisons, usually report of having been abused there. These children are also now more vulnerable to Israel's attempts to recruit them as informants against their society. And in addition, they're more likely to be abused by their Palestinian peers, because reports suggest that in the past, Palestinian adults helped the children peacefully resolve their disagreements and tensions. The generational segregation has also made it easier for Israel to narrow down the rights of Palestinian adults in prisons. The book reveals how Israeli judges presented this reform as a way to prevent unwanted knowledge transfer from one Palestinian generation to another. According to Israeli judges, Palestinian adults are incorrigible, whereas for Palestinian children, there is still some hope of depoliticization. Israeli courts have used a similar rationale to authorize the retraction of certain benefits that were previously available to Palestinian adults in prison, such as enrolling in open university courses. In some of my previous work, I exposed parallels and connections with the generational segregation of other groups in other times and places. And I focused on the systematic removal of indigenous children in the US, in Australia, and in Canada, and also on the ongoing removal of Uyghur children in China. One of the chapters in the book builds on some of this earlier work while also developing it further. Now, human rights actors have mostly failed to consider the limitations and pitfalls of international legal and human rights norms. For this reason, they strongly advocated these detrimental reforms for many years. And only now, after the fact, they're starting to increasingly realize the harm that has been done to Palestinians. So as we can see, the human rights community has much more in common with Israel than is usually believed. On the one hand, Israel has come to increasingly harness the language of and mechanisms of law and human rights, including international humanitarian law and children's rights, while on the other hand, human rights actors have repeatedly pushed for measures that Israel eventually adopted with harmful consequences for Palestinians. So the book also reveals how human rights organizations often ignore the voices of the Palestinians they claim to serve. In some cases, they operate contrary to what they themselves quote Palestinian children as saying. For example, here's what a 12-year-old Palestinian told Israeli NGO B'Tselem in 2008, after he had been imprisoned with Palestinian adults. And I quote, "The Israeli soldiers took me and a 14-year-old friend to an Israeli prison and put us in a section which had 83 detainees of all ages. The detainees treated us well. I felt comfortable. A detainee helped me ask for the doctor to treat my leg. At first I was afraid and cried sometimes because my family was far away. The adult detainees took care of me because I was the youngest detainee in the department, and they decided to make me assistant to the detainee acting as sergeant of the department, end quote. And the book provides one example after another of Palestinian children repeatedly describing Palestinian adults as a source of support, protection, and empowerment in Israeli prisons. And yet, the NGOs that quote these children completely ignore what they say. For example, the report that contains this particular quote criticizes the fact that the child was held with adults, even though the child himself describes this as in an unequivocally positive light. But the book brings to light many other problems with the human rights community. Among other things, some human rights organizations have described Palestinian adults as a potential security risk, especially in terms of their influence on Palestinian children. In this way, these human rights actors reinforce the security discourse that underpins Israeli state violence. If these organizations are using this problematic rhetoric for tactical reasons, then it's a failed tactic because, as we've seen, it doesn't actually benefit either Palestinian children or adults. And in some respects, it's actually been detrimental for them. And on top of all of this, human rights actors often assess human rights violations in isolation from their structural causes. And they're also limited by their need to keep donors and lay audiences interested in local issues that are both complex and contentious. The book also illustrates another pitfall. That is the tendency of the dominant human rights discourse to marginalize more radical, emancipatory discourses. Sometimes it marginalizes these alternatives by making them appear too political, ideological, or subjective. Other times it marginalizes them by engrossing public attention, resources, and imagination at their expense. And as part of this tendency, human rights organizations often focus on reforming rather than abolishing Israel's military rule over Palestinians. And a key reason for all of this is the fact that the dominant human rights discourse frames both the problems and the solutions primarily in legal terms, with special focus on international law. The report of the British delegation offers an example for this tendency as well. So the report describes several guiding principles, and this is a phrase used in the report, including the following, and I quote, "Without embarking on its desirability, we treat as a given fact the use of military courts to try Palestinian civilians, in particular children. Our aim is only to assess whether Israeli military law and practice meet the standards of international law and international children's rights." This framing is very convenient for Israeli authorities because, as I've shown, they're very well versed in the playing field of international law and human rights. And the reason I keep revisiting this particular report today is that we're at a British university, and I'd like to highlight the involvement of the UK, but the book obviously examines a much broader array of human rights actors, which include NGOs, both international and local, as well as UN bodies and scholars. The example I've focused on so far is the generational segregation of Palestinians in Israeli prisons. Now let's have a look at a second example, which concerns the so-called right to childhood. So when human rights actors claim that children deserve special protection, they frame this claim in various ways. And one way is to claim that childhood itself is a right. Take, for example, this statement by an Israeli NGO called the Public Committee Against Torture in Israel. And I quote, "Childhood is not a privilege, but a right. Torture destroys childhood. The threshold in which an act of abuse would be considered torture in the situation of an adult must be lowered when it comes to children." End quote. In other words, the message here is that when Palestinian adults are concerned, harsher torture, harsher abuse is legitimate. Now, human rights lawyers often claim that torture is always illegal under any circumstances. But what we see here is a distinction being made between two levels of torture, one for children and one for adults. In this way, the child rights framework ends up condoning state torture against Palestinian adults. So as we can see, the discourse of children's rights is often about adults, no less than children. And these adults include not only those who have direct responsibility over children, such as parents, teachers, and social workers. They also include other adults, such as those in Israeli prisons, or those who are tortured by Israel. By singling out children, the discourse of children's rights legitimizes violence and apathy towards adults. Another example I'd like to mention illustrates another pitfall of the special protection rhetoric, and it has to do with the Israeli closure of the Gaza Strip. As some of you may know, Israel controls travel and access to and from the Gaza Strip by land, sea, and air. And in the first years of the closure, Israel also heavily restricted the amount of food and calories that were permitted to enter Gaza. Documents obtained from the military show how Israel divided the population of Gaza into age groups. Then, each group was allocated a different amount of food and calories. For example, a Palestinian under the age of 10 was allowed to consume a daily average of 1,758 calories and 1,448 grams of food. And in this way, the age composition of the Palestinian population was used against it as a tool of biopower, which then enabled Israel to micromanage life in Gaza. But for Israel, basing food quotas on age also served another function. It was used as part of the Israeli attempts to garner legitimacy, both domestically and abroad. So, for example, the Israeli state attorney argued that this economic warfare was compatible with the Geneva Conventions, which are considered the cornerstone of international humanitarian law. And here's what the state attorney argued. I quote, Article 23 of the Fourth Geneva Convention states, parties to an armed conflict shall permit the free passage of all consignments of essential foodstuffs intended for children under 15. Clearly, the premise of this proviso is the waging of economic warfare as part of the parties' armed conflict. Implicitly, this proviso recognizes unequivocally the legality of this practice and merely seeks to set a minimum threshold for it, end quote. So it's not a coincidence that Israel quotes international law to legitimize its continued control over Gaza. The aim of international humanitarian law is to regulate the conduct of armed conflict through certain principles such as proportionality and distinction. As we see, some of the legal distinctions are based on age, and this helped Israel portray its food restrictions as both lawful and humane. In this way, contemporary warfare speaks the language of international law and humanitarianism while professing a commitment to the sanctity of human life. One last example I'd like to mention in this context concerns Israel's use of warning posters. One of the chapters in the book describes Israel-Palestine as a visual battlefield. So the chapter examines a broad range of visual and rhetorical strategies used by Israel, by Palestinians, and by others, and it investigates how these strategies determine what can be seen, known, and said about state violence and about childhood. So one of the state practices I discuss is Israel's use of warning posters. In recent years, Israeli forces have repeatedly put up warning posters in Palestinian villages and towns. Some posters, such as the one shown on the screen, contain photos of Palestinian children who've been placed behind bars for throwing stones at Israeli soldiers. Other posters, instead of using photos of children, use the photos of their parents. Either way, the posters warn Palestinians that the military is monitoring their actions and that any transgressions would lead to punishment. Interestingly, these posters tend to use the language of children's rights. And they present Israel's conduct as protecting Palestinian children. So, for example, one poster addresses Palestinian parents in the following way. I quote, "If you do not want your photos to appear in a notice like this one, tell your children to stop the acts of aggression for the sake of their safety and their future." So as you can see, Israeli authorities repeatedly speak about the future and best interest of Palestinian children. In the name of these interests and future, Israel justifies its surveillance and oppression of the Palestinian society. So far, I've called into question two common narratives. One was the claim that Israel simply disregards human rights and international law. The other was the rhetoric of special protection. A third narrative, which is also challenged in the book, is the claim that Palestinians are being robbed of their childhood. This is a common trope in human rights reports and also in some of the academic literature. One example appearing on the slide is a book titled Stolen Youth, which deals with Israel's detention of Palestinian children. It was written by 3 academics and published in collaboration with Defense for Children International. Another example is a report by the Council for Arab-British Understanding, which is a not-for-profit cross-party organization here in the UK. According to the report, and I quote, "Palestinians have been unable to prevent the steady erosion of childhood." But this narrative is problematic for so many reasons, and I'll just mention one. When Palestinians are being described as having their childhood stolen from them, what we're presented with is a romanticized conception of childhood, which is insensitive to the actual social and political context. The reality is that Israel doesn't deny childhood. Instead, it imposes on Palestinians a certain model of childhood, which is enshrined in law and human rights. And as the book shows, this legally enshrined childhood operates to govern, discipline, and disempower Palestinians. A fourth and final narrative challenged in the book is that law and human rights offer the solutions for Israel's wrongs. And in light of everything I've said so far, it should come as no surprise that law and rights are not merely the solution, but also part of the problem. There are various reasons for this issue. I'll just mention 2. The first is the plasticity of both law and human rights. And what I mean by this is that law and human rights lend themselves to competing interpretations and to competing uses. And because of this, states often use the language and mechanisms of law and human rights to shape and legitimize their violence. The second reason for this issue is that both law and human rights rest on certain generalizations and abstractions. As a result, they're often applied without sufficient sensitivity to the context at hand. And child rights are premised on a specific abstraction, which is a certain model of childhood. And as I've mentioned, this model is supposedly universal and natural, but in reality, it often marginalizes children, it paves the way for harming adults, and it suppresses valuable forms of life and thought. And these issues are not unique to Israel-Palestine, obviously. For example, in some of my previous work, I've examined the use of torture by other countries, including the UK and the US, and I discussed how law has been used to shape, legitimize, and conceal the use of torture in those contexts. The unique contribution of the book in this regard is both theoretical and empirical. First, the book brings together insights from critical legal studies, critical human rights studies, and critical childhood studies. And second, it brings to light previously unknown findings about how specifically law and human rights contribute to state violence in this particular context. These findings are based on my analysis of various sources that have never been examined, including hundreds of Israeli legal documents that are not publicly available. And I'm happy to elaborate about this later if anyone is interested. So far, I've challenged and complicated some common narratives and perceptions about law, human rights, and childhood. But the book also tackles various other issues, and I'd like to touch on a few of them. First of all, the book doesn't only deal with state violence. It also discusses various forms of popular resistance. And one example relates to the travel restrictions that Israel imposes on Palestinians. These restrictions limit the ability of Palestinians to access their territories, their communities, their families, medical treatment, work, and resources. And as the book demonstrates, Israel uses age as a risk management tool. And one of the ways in which it does so is by placing different restrictions on different Palestinian age groups, with the major brunt being borne by adult Palestinian men. The book reveals how young Palestinian men tried to resist these measures by manipulating their perceived age. When they were caught entering Israel without permits, they lied to the Israeli authorities about their ages and presented themselves as children. As a result, they were given slightly lighter sentences, but later their chronological ages were revealed and they were punished not only for entering Israel, but also for misrepresenting their ages. So as we can see, childhood is performative, and this performativity makes childhood not only a tool of state control, but also potentially of resistance. Another example has to do with resistance by Israeli settler children. The book consists of 8 chapters, and most of them are dedicated to the discourses and practices of law and human rights as they relate to Palestinians. But the last 2 chapters also deal with issues concerning Israeli settlers in the Palestinian territory. And one of these issues is the resistance of settler girls who were arrested for participating in proscribed protests. The book discusses how these detained girls refused to disclose their identities to the Israeli authorities. And what the Israeli legal system found especially troubling was the inability to know their ages, because this made it impossible to put them into a legal age category and treat them accordingly. And the book uses this as an example to reflect on the political power of remaining silent, both in relation to children and more broadly. Even though these 2 examples are obviously very different, what they both demonstrate is the performativity of age, and they show how this performativity and how the fact that age is determined by multiple factors enable both Palestinians and settlers to try to resist the law. Another theme discussed in the book is that of infantilization. Over the course of human history, various groups have been infantilized. Among them are women, non-white people, the elderly, the global south, people in trouble with the law, and those with mental health issues. The infantilization of these groups has reinforced their perceived status as deficient, incapable of exercising certain rights, and accordingly as being in need of special supervision, control, and even outright subjugation. But the book examines the infantilization of another group, which is Israeli soldiers. I investigate how they're infantilized in both legal and human rights discourses in Israel. And I pay special attention to court cases involving soldiers who were caught abusing Palestinian children. I show how Israeli courts conjure up two potentially conflicting childhoods. So on the one hand, there's the violent soldier, who isn't formally a child, but tends to be perceived as such in Israel. And on the other hand, there's the young Palestinian victim, who is an actual minor, according to the applicable statutory definitions. And this rhetoric helps Israel cast its violent soldiers as both children and victims. The last theme I'd like to mention is the rhetoric of mental health. The book critically examines how human rights actors use psychological expertise and terminology, especially the concepts trauma and loss. Among other things, the book shows how the mental health language individualizes, depoliticizes, and potentially decontextualizes the issues that it aims to convey. And it also pathologizes Palestinian children. And this is yet another issue that characterizes other contexts as well beyond Israel-Palestine. But in Israel-Palestine, some human rights actors add another warning. They suggest that if the trauma of these Palestinian children is left untreated, they might become a threat to Israel's security. And in this way, the human rights community once again reinforces the Israeli security logic rather than challenging it. As you may remember earlier, I mentioned how some Israeli NGOs similarly describe imprisoned Palestinian adults as a national security threat. So this is yet another example of the overlap and commonality between Israeli authorities and their human rights critics. In conclusion, I should reiterate that many of the arguments in the book are applicable to other contexts beyond Israel-Palestine. And the book repeatedly points this out. Among other things, the book links Israel-Palestine to laws, policies, and attitudes in other times and places. Specifically, it discusses global issues regarding children, their rights, and their legal status. It examines issues concerning armed conflict and counterinsurgency, and it draws parallels with colonized peoples, with racialized minorities, and with non-citizens around the world. So I think I'll stop here. Many thanks for listening, and I'm happy to answer questions and to discuss all of this further. Thank you very much.
Thank you so much for an absolutely fascinating presentation. I would just like to remind those of us who are here, if you have a question, you should have a Q&A box, not just using the chat function, and you're welcome to pop any questions in there. I will start off with a question that's actually been provided by Charlotte, who wasn't able to make it today. She's curious about, having read the introduction and some interviews, your criticism of the construction of the child-adult dichotomy, which ignores the category of adolescence. And she asked whether you have any ideas how law in general and human rights law in particular may be able to escape this.
I would say, first of all, thank you, Charlotte, who's not here today, but hopefully she can see this recording later. So thanks, Charlotte. I would say that my criticism goes even further, because I know that there are some within some children's rights scholars who do criticize this child-adult binary. They say that it's not attentive enough to the specificities and to age differences in different contexts. And what's been promoted by those scholars is greater attention to adolescence as a distinct category. And increasingly, alongside that trend, there's also growing focus on what is called young adults. And that is informed by the growing symbolic power of brain development studies over both scholarship and policy. I'm even more critical because I think constructing adolescence as a category and constructing young adulthood as a category doesn't really address the issues that I identify, which are essentially about what I've called in my work age essentialism. So what these subcategories essentially do, they just break the dichotomy into smaller categories, but they don't do away with the age essentialism of it all. And again, this is not an issue. Those in the audience who work on other contexts and other settings involving childhood and children's rights would be familiar with possibly with criticisms of this, what I call age essentialism in other contexts. And I'm thinking here, for example, about issues surrounding child work, or as some critics refer to it, child labor, child refugees, child combatants, child carers. Many issues come to mind where these categories don't do justice both to the voices, to the potential, and to the circumstances of people of all ages, which, by the way, is one of the reasons why in the book itself, I don't actually use the words children or adults or adolescents, unless I'm quoting someone. I use vaguer phrases such as young people, which I think would be unhelpful to those who seek clear-cut, legalistic delineations. But I think reality is actually very vague and very messy. And when we see someone, we don't necessarily know whether legally they're a child, an adolescent, an adult. And I think the vagueness of the language that we perhaps should consider using could better reflect the messiness of the reality that we're trying to capture or reflect on. I would just say that I see the point there. I think there is a merit in distinguishing between different young age groups to some extent. For example, some of the context I was talking about in relation to Palestinian children. Let's revert to that word now, which I've been using in my talk just to make things simpler. Those issues relating to children in conflict with the law, we know that they're not actually about all children, which are defined under the CRC, the Convention on the Rights of the Child, as anyone under the age of 18. They actually concern mostly teenagers under the age of 18. So speaking about children in that context is sometimes very convenient for children's rights advocates, but it doesn't do justice to the actual dynamic of those situations and also to what those young people report. So I think if we did want to use a term in that context, perhaps we could consider youth, which I know is also not an unproblematic concept, but again, it's more vague. So it enables us to think against and beyond some of these binary and very rigid concepts. I think, yeah, you were muted.
Yes, thank you. And I realize that's a very difficult question to answer, but I think the guidance you've elucidated there is really insightful. I would now like to move on to a couple of questions that have come in, both about sources and evidence. The first one would like you to elaborate on the disconnect between the evidence that human rights groups gather and the recommendations they make. Specifically, is there any evidence that can help us know why there is this disconnect or the failure to listen to Palestinian voices? And is this a phenomenon that you have noticed in any other contexts?
So many thanks to whomever asked this question. It's very helpful and it can take us in several different directions. So I'll say a few things. First of all, there are indeed many examples in the book. It's very striking and troubling because you see the example and then you see not only a policy being pushed that runs contrary to that very explicit quote or statement, but also that disregards it completely or reframes it by attaching a headline to it or a title that fails to represent even remotely what the statement says. So there is kind of, it does beg the question of why are they doing it? So I'll say two different things about that. One thing is that I think I have tried to allude to potential explanations of that. And those explanations, I think potentially, because I'm not claiming to know why they do that. I'm not a mind reader, nor do I think they necessarily always act consciously. I don't think there's always intentionality behind every action. I don't think everything we do is fully transparent to ourselves, let alone, obviously, when we do something with a certain objective in mind, we cannot anticipate what the actual objectives will be, but that's a separate issue. So I'm not claiming to know what they actually have in mind, but some potential explanations have to do, I think, with the conceptual frameworks within which they operate and the constraints that they're subjected to. So in terms of conceptual frameworks, I was alluding in my talk to how I think the human rights community is heavily legalistic, meaning that it both thinks in legal terms, but also that many of the senior people and staff members are themselves practicing lawyers or have some legal training, either academic or just having attended a growing number of legal workshops on what international law says. And I think everything increasingly is being framed as a legal issue. Once you do that, it becomes very difficult to imagine something that goes outside or against what is perceived to be an international legal norm. I'm saying what is perceived to be because, as I mentioned earlier, law is more fluid and plastic than sometimes lawyers would have us believe. So I think that's one potential explanation. Another is that children's rights practitioners are also operating within a certain framework in relation to the conception of childhood. So if childhood rests on distinction, meaning the distinction, the fundamental distinction between a child and an adult, and if that distinction is then assumed to require spatial separation, right? Not just in prison and in what Israel now refers to as the military youth court, or just the usual youth court, but also work versus school, right? We know here in the UK, in playgrounds, how entry is sometimes restricted only to children and those who accompany them, because that is a space for childhood. That is a childhood space. Adults are no longer expected to play. We're beyond that stage, supposedly. So all of those spatial separations are assumed to be beneficial for everyone and necessary and natural. I think it's very difficult to even imagine that there would be any context where this wouldn't be so. But again, I will reiterate that all of these are possible explanations that I'm providing. And I explicitly say in the introductory chapter that I'm not claiming to identify, my analysis is not in terms of intentions. I think analyses that are based on intentions are potentially problematic. I mentioned earlier the issue with assuming that there are intentions where often there aren't. People are just acting automatically. There's also the problem in relation to state practices of talking about intentions, because if we focus about intentions, it makes it very convenient for the state to then argue that what it does and whatever harm was caused was not intended. So then the focus becomes on intentions, and that potentially excuses violence and harms. So normatively speaking, as well as epistemologically, I think the concept of intention as an explanatory concept is somewhat limited. Now, I'll now turn to the other part of the question, which was, are there any other contexts in which in my work I've noticed this? So the answer is yes. I recently published a chapter in an edited collection on youth imprisonment, and that chapter moves outside Israel-Palestine. It's not about Israel-Palestine. it's about considering the blind spots and limitations of, but it is related to what I was talking about today, the blind spots and limitations of the legal and human rights norm that requires separating youth and adults in prisons, generally around the world. And I refer there to international law, UK law, US law, just more broadly. Just to clarify, I'm not claiming that children and adults should be imprisoned together, because I don't support imprisonment as a categorical solution to social problems. What I do think is that we need to think beyond age essentialism and beyond what I call in my work carcerality or carceral thinking. So I'll just put it out there. But I have found, to return to the question, which was about whether there are other contexts in which human rights actors operate against the evidence, I have found, for example, one human rights report after the other that only partly quote the provision in the CRC, in the Convention on the Rights of the Child, which is Article 37b, the provision that requires separating children and adults from in prison, because the full text of that provision actually says that children should be separated from adults unless it's in their best interest not to be separated. And what we see is that human rights, the norm, the separation norm, is so powerful that the exception, the inconvenient exception, is just completely erased. And we see that in a large number of human rights reports, that caveat at the end is just not included in the quote. It's not presented. And we also know, and I show in my work, how prominent UN bodies have argued that this provision should be interpreted so that the exception, the non-separation exception, should be extremely narrow, almost non-existent. So returning to the first part of the question, if you're a children's rights practitioner and you're trying to think of problems and solutions, and you envision childhood as being one single thing universally, and you envision what's best for children through international legal norms that you see as dictating one very clear thing, for example, in the context of imprisonment, then I think it is very difficult to imagine anything else. And on top of all of that, just imagine the challenge of then having to mediate all of those complexities to audiences that have no knowledge whatsoever of the intricacies of Israel-Palestine. Try to go to a foreign audience and tell them, we are an NGO that now opposes the separation of children and adults in prison. I think it will become very difficult for that NGO to get funding, because it will then need to explain why it's promoting this very unusual policy. And that requires a lot of attention and patience to details and openness, which I don't think the media necessarily has. I don't think audiences have, and I don't think that's a risk that NGOs feel like they can take. So that's a very long-winded answer, but I think that's just because there are so many factors at play here.
Yes, it's a very complicated situation. I have a question now from Lama. Would you like to ask this yourself? I am happy to pass over the mic to you, or I'm likewise happy to read it aloud.
Yeah, sure. Thank you. First of all, thank you for this really fascinating talk. My question is a bit of being the devil's advocate. So some may argue that the rhetoric of the innocent child or the vulnerable child or the stolen childhood has a political value that overrides its potential harms. So do you think the use of the children's rights framework, especially by NGOs, can be a politically useful tool to expose Israel's apartheid state, simply because the public opinion, the international public opinion, is more likely to sympathize with children because they are seen as innocent and vulnerable, rather than quote unquote violent adults?
Thank you very much for that question, Lama. I will say, in the interest of nuance, that I think a discourse can evolve, can transform. I don't think the human rights discourse necessarily, or the children's rights discourse necessarily, is one single thing. But I do think it's limited. So I think it makes certain things very difficult. And that's kind of an introductory comment about considering what you call the political value of some of these tropes, as opposed to their costs. So let me say something potentially challenging. When considering the political potential of some of these tropes and some of these narratives, if we do agree that they're ageist, they are ageist in the sense that they single out certain age groups. Those age groups are singled out because they're seen as having a symbolic currency, because they more easily evoke compassion, whereas other age and gender groups potentially don't, so they're left out. If we do agree that that is ageist, then I think the question is really, is ageism legitimate when it's seen as potentially valuable? Now, I would argue that it's not nearly as valuable as people tend to think, and in many, many instances, it's actually harmful, and that's part of what the book tries to do. So first of all, we need to recognize that. But let's just assume, for the sake of the philosophical question, let's assume this discourse did no harm other than being ageist. If we could isolate that as an issue, would that be justified? To me, that seems problematic, in the same way that I wouldn't use a racist discourse, even if I was using it within a racist society, where, for example, singling out blonde white children would evoke more compassion than talking about non-white children. There are many societies in which, unfortunately, that is still the case. We know in advertising, sometimes even today, certain figures, certain people are being chosen as models because they are seen as more representative of, quote unquote, our product. That is racist. That can be objectifying to women sometimes. Now, does that sell cars or products? Maybe sometimes, if the audience is racist or misogynistic or whatever. But I think what it also does is reinforce those problematic notions. So every time we evoke or invoke the child as this supposedly very emotionally evocative character, we also entrench this ageism. And in every invocation of the child, we make the Palestinian adult Muslim men seem even more like, by default, seem even more like this dangerous character, unworthy of our solidarity and our compassion. And obviously, everything I'm saying now applies to so many other contexts which have nothing to do with Israel, Palestine, and I'm sure many people in the audience can think of some issues that have to do with racism and classism and many other issues. So I think that in and of itself is a problem. It reinforces ageism. Now, on top of all of that, what the book actually shows is that there are many instances that are presented by human rights advocates as victories in terms of children's rights, but they're actually not. So raising the age of majority from 16 to 18 years, it was a symbolic success story. It made no difference to the way in which these young Palestinians are actually treated in practice. They're treated exactly the same, other than being now labeled as children. It doesn't matter. So that made no difference. And some of these other reforms, as I mentioned earlier, seem like a success story, but they're actually very detrimental. So there are two issues here, both the failure to actually achieve those benefits that we're told are being achieved in the name of children's rights, as well as this reinforcement of ageism and this legitimation of apathy and harshness towards adults and especially adult men. I think that's these two issues deserve more attention than they usually receive.
Thank you. I will just loop back now to another question on sources. And given that you mentioned you had been keen to escape the reliance on official Israeli sources and to access the previously unavailable military court decisions, what strategies did you employ to negotiate access to that sort of material, and how did you frame your research in a way that ultimately persuaded the authorities to allow you access?
I think it was, I think my project itself has evolved over the years. So when I started, this began as a doctoral project many years ago, and then Chelsea, the two of us were discussing this before the event. I shelved it for a while, worked on some other projects, but constantly continued to update and revisit it, and eventually this book has been published. But during my doctoral studies, initially, at least, I approached this as more of a sociology of childhood project. It took me a few years. For example, I'm talking now about how separation in prison, age-based separation, is problematic, but that wasn't my starting point. Actually, I started, and when I started my project, it was before there was full separation. So my assumption was that it's problematic that children are not being sufficiently separated. I reversed some of my own assumptions. And I think I also have become, and I'm still on that journey, to become increasingly critical as an Israeli Jew, to become increasingly critical of my own country, just because I think with time I get a better perspective, and also a comparative perspective. I alluded earlier to how some of my work is contextualized within broader historical and global context. And I think those comparative and global perspectives potentially allow one to draw links and parallels and connections that kind of shed a different light on some of these issues, and also enable me to think through different conceptual frameworks. But all of that is just to say that when I initially contacted the military, it was mostly presented as a sociology of childhood project. I think they were extremely baffled by it, but because the military judgments, even though the military courts are a very central part of the Israeli legal system, this is the first book ever to analyze Israeli military judgments. And there's a reason for that gap in the literature, both a political reason and also because of the difficulty of accessing these materials. It took me a few years to access them. So I think that framing didn't seem that that menacing, but it was very authentic at the time. But I also have to say that being an Israeli Jew and with my symbolic capital, I think I was able to benefit, to gain access, and I also know some very senior people within the Israeli legal system and the Israeli military system. I was able to gain access that I think non-Israeli Jews would not have been able to. And I think that's why even though I talk about Palestinian resistance and I try to highlight Palestinians' voices, I was motivated by using my privileged position to unearth these, among other things, these state documents that I thought others might not gain access to. So I think it's a combination of how the project was framed very authentically, very genuinely at the time, and also my own positionality, my privileged positionality. But I will say that when I visited the courts and I went to the archive, I was constantly under surveillance by soldiers who at the time initially assumed I was an NGO worker because no scholar had ever been there to analyze these materials. And I also remember very vividly being asked by these very young soldiers, but very genuinely, why is this interesting? And this was not a criticism. This was a genuine, they couldn't see why anyone would care, because that's where they were based at the time during their military service. It seemed endlessly boring to them. They didn't see why anyone would care. And obviously not many people did care at the time. So yeah, that's the answer to that.
Thank you so much. I think we're almost at the end of our time today. Before we finish, I was wondering, you spoke about your network. How should people get in touch with you if they would like to be added to that network? Thank
you for that. If you just Google me, you can find my email address and just contact me. We have, I'm working with a team and we have an online membership form, which is very straightforward, that people just have to fill out to join. It's supposed to be a very interdisciplinary and global network. So it is for lawyers, but it's certainly not just for lawyers. We have already, I think, more than dozens of education scholars and psychologists and philosophers and sociologists. So really everyone is welcome, because we want this to be a very broad church, and we want to encourage these cross-disciplinary conversations, because I think we have a lot to learn from each other. And I think often we deal with overlapping issues, or just having conversations where we could learn from each other much more than we are aware. So yeah, just get in touch by email.
Thank you so much. And just on behalf of Bonavero and the Children's Rights Network, thank you for your time. I am sure that everyone else enjoyed your presentation as much as I did, and especially your responses to the questions which were raised. It was excellent. Thank you so much for your time, and I hope you have a lovely afternoon. Thank you for joining us.
Thank you.